Welcome to Cross-Border Tax Talks, where we discuss the latest trends in international taxation, from U.S. tax cases to the OECD's latest developments. I'm Doug McHoney, PwC's International Tax Services Global Leader. The Pillar 2 engine from PwC is a game changer for Pillar 2 modeling, provision, and compliance calculations. Built on a graph system utilizing over 20 years of international tax technology, this centralized rules engine is built by a team of Pillar 2 tax experts from around the globe. PwC's Pillar 2 engine is currently available as a service and is now available to license. On this week's episode of Cross-Border Tax Talks, we're back in PwC's Policy on Demand studio in Washington, D.C., where I'm excited to have Wade Sutton back on the podcast. Wade is the International Tax Leader for PwC's Washington National Tax Services practice. Wade, welcome back to the podcast.
Yeah, thanks for having me.
So, Wade, I like to start these podcasts with maybe a light initial question, but in follow-up to our original podcast that we did on Moore, I'm going to try to be a law professor here, and we're going to take a little bit different approach. And I want to caveat that I am not a law professor. I did go to law school, and so I may struggle with this, and I know we have a number of academics that listen to this. But before we dive into some recent Supreme Court cases, which could have a significant impact on the U.S. tax system, or may not, as we'll see what your views are on some of this, Wade, over half of our listeners on the podcast are generally outside the U.S. And so I was hoping that you could start with providing a little context, because we're going to be talking about 3 Supreme Court case decisions. And the U.S. system is very different than some other systems in that it's a common law system in the U.S., really based on the English version of the common law system from the Middle Ages, as we compare that to a civil law system, which is generally more mainland Europe, and we certainly see some countries in Asia. But can you provide a little context? What is the difference between a common law system and a civil law system, and why are these Supreme Court cases so important for U.S. tax law?
Sure. I think the important thing, particularly for foreign listeners to understand, is the Supreme Court here is the highest court, federal court in the land, and what they say is binding on all of the lower courts. So when there's a dispute with taxpayers and the government, that starts out, for example, in a district court that may be in a specific state or a region of a specific state. If that's appealed, that will go to a circuit court, which often has jurisdictions over multiple states. And then oftentimes, if there's a circuit split or an important issue of law that the Supreme Court wants to clarify, that goes up to the Supreme Court. They're not bound to take every case. And what they say changes the law for the entire country. And I think one really important thing to keep in mind here is the Supreme Court doesn't take a lot of cases. Each term, they're taking about 60, say. And so when they take a case, it's oftentimes they want to course correct or guide the lower courts where they think they might be off kilter, right? And so oftentimes these are big symbolic pronouncements, and we don't quite know. We'll get into this in a lot of detail in some of the other cases discussion, but we don't quite know how this is going to be implemented over the next few decades. And so these big symbolic pronouncements from the Supreme Court are important, and they bind the lower courts, but there are a lot of open questions that ultimately the lower courts will have to wrestle with.
Yeah, and as we compare that to, say, some of the countries in mainland Europe, a common law system is based on judicial precedents. Civil law system is based on legal codes. We obviously have legal codes here in the U.S. What I think makes our system a little different here in the U.S. is that the legislature comes up with these codes, and then, in this case, the courts then interpret some of those rules, when there may be ambiguities, uncertainties, whatever the case may be. And then whatever the Supreme Court decides with respect to the interpretation of those codes is precedent.
That's right.
And as we compare that to civil law countries, sort of each case is generally on its own merits that doesn't provide that precedence that we see in the U.S.
Yeah.
So hopefully that provides a little context. So we're going to start with Moore, and we dedicated an entire podcast to this, and we're not going to force our listeners to go back. And so what we wanted to do for the format for this podcast, Wade, is, again, kind of back to law school, where we were tortured in law school briefing cases.
Yeah.
And so what I wanted to do is kind of go and actually brief the 3 cases that we're going to talk about, which is Moore versus the United States, Corner Post, and then the Loper Bright decisions. So let's start with the Moore case.
Sure.
Mr. Sutton, What are the facts of the case? I'm going to try to come up with some hypotheticals and some pushback, but I would be a very poor law professor. I'll caveat.
Don't sell yourself short. But yeah, we've covered quite a bit. So I'm going to do this briefly so we have time to talk in detail about some of the other cases. But the high level facts are pretty simple. We had a couple based out of Seattle that invested in an Indian company. They received a minority interest in the company, and that Indian company earned profits. And prior to the enactment of the Tax Cuts and Jobs Act, if that Indian company did not earn Subpart F income, its earnings were not taxed to the shareholders until they were distributed, right? It was a deferral system. The Tax Cuts and Jobs Act, or TCJA, when that was enacted, we went from a deferral system to really a worldwide taxation system. There's a participation exemption, but for the most part, earnings of foreign corporations are taxed on a current basis.
Under our GILTI regime.
That's right. And as a transition from the old system to a new, there was this transition tax under Section 965 that taxed all of the prior earnings of these foreign corporations that had not already been subject to tax under Subpart F at a lower rate as part of a toll charge. That happened to these individuals who owned the minority interest in the Indian company, which happened to be a controlled foreign corporation. And their argument in the courts, they made a couple of arguments, but the important one that made its way up to the Supreme Court was this is unconstitutional under the 16th Amendment because there's a realization requirement. That was their argument in order to have income. And we haven't realized any income. We didn't sell our shares. We didn't receive dividends. In fact, we were minority shareholders, so we couldn't even constructively receive dividends because we had no ability to compel a distribution to us. So they lost the case in the lower courts, at the district court, and at the Ninth Circuit. And then that went up to the Supreme Court. They had also made some due process arguments in the lower courts. They did not preserve those arguments. They only put forth the 16th Amendment. And I think we've covered this on prior podcasts, but the constitutional issue here is in order to have a direct tax that is not subject to apportionment, and that means it has to be evenly apportioned amongst the states according to population, which no one does.
Right.
It has to be an income tax. And so their argument was this 965 transition tax was not an income tax because there was no realization of income here.
All right, so we covered the facts. I think you actually gave a little bit of the procedural history as well as the issue. What about some of the prior precedents, and we'll make from a historical perspective?
Yeah, so I think the one that the plaintiffs here would hang their hat on the most was Eisner v. McCumber, and that dealt with a stock dividend where there was a corporation that issued shares, additional shares to a shareholder, and the government attempted to tax that distribution to say that you realized income when you received that distribution of shares. And the court there said, well, no, that's not a realization event. You really didn't own anything different than what you started with. And without that realization event, you cannot be taxed on that income. It was a constitutional case. And in a sense, that case has been narrowed. Some would say it had been overruled and should not have been followed. And so I think that was kind of front and center. The dissent in the Ninth Circuit had really highlighted this issue because the judge that ruled for the government there said there is no realization requirement under the 16th Amendment. And I think that got the justice's attention at the Supreme Court. I think in the back of their minds, there may have been some thought that what's really at play here is potentially a wealth tax, right? Where there's a lot of discussion on the Hill about mark-to-market taxation or wealth taxes on billionaires. You hear a lot of that in the press. So there's a question of, could you do that if there's not a realization event? And I think, that is likely. We're speculating a little bit here, but why this case caught the justice's interest.
So what was the holding in the case? What did the Supreme Court decide? So
it was really interesting. Everyone expected something really big and important out of this case, and I don't think they got that. It was a very narrow ruling. So, for example, the majority opinion did not address whether or not there was a constitutional realization requirement. They didn't have to because they said it was met in this case. And the way they got there was they said that earnings were realized at the Indian corporate level. And those earnings and realized earnings could be attributed to the shareholder. Now, some of the justices, particularly in some of the concurring opinions, this was a 7-2 decision, which, by the way, I predicted.
You did, I think, on the podcast.
Yeah. So some of the justices noted that there could be some due process limitations on whether or not it was fair to attribute earnings of a corporation to the shareholders. But because the shareholders here had dropped their due process challenge at the Supreme Court, that was not before the court, so they didn't have to answer that question. And so, I think from a majority perspective, if you look at that opinion, I don't think we learned that much. They were pointing to old cases that said it was fair to attribute an entity's earnings to the shareholders. There were a number of cases like that from the 30s. They didn't address whether the 16th Amendment had a realization requirement. And so in a way, it was just a reiteration of what we already knew about the law.
So why did this capture the tax world's attention, particularly here in the U.S., and kind of going to some of the foundational principles, and maybe to remind listeners that we have this the toll charge, which gathered this income from those deferred the earnings and profits from those deferred profits, and were immediately subject to tax. But in the U.S., we also have our controlled foreign corporation regime, something called Subpart F, which also taxes earnings of a CFC. We have these pass-through provisions that we like to refer to as our Subchapter K, which applies to partnerships, Subchapter S, which is really a pass-through for corporations. So how were those potential areas potentially impacted, or could have been impacted, by the decision?
Yeah, it's funny. There was a line in the majority opinion by Kavanaugh that mentioned the blast radius from a potential decision in favor of the taxpayers. And I think that's right. The tax community, particularly in the amicus briefs, just poured in all of these examples.
There were a lot.
Yeah. You should really think carefully about what you're up to here, because this is a load-bearing pillar of the tax system. And if you were to take this, to say that there is a realization requirement and that it's not met in this case, then all the examples you just mentioned might be suspect. Original issue discount taxation, the pass-through taxation of partnerships and S corporations. There's a long list of really important revenue collecting mechanisms in the tax code that might be suspect. And I think, again, I'm speculating here. I don't know that the justices quite appreciated the scope of the issue that they were wrestling with until they got these amicus briefs.
Yeah, when they agreed to hear the case, they're not sure that they. And first of all, I appreciate you using the term pillar in this, outside the context of pillar too. But this would have been a foundational change, and I think your point is that I'm not sure the Supreme Court understood how much of a foundational, just massive change this would have been if they would have ruled for the taxpayer.
Right, and there was actually some suggestion, at least in the tax community, that maybe the court should. They granted cert, but you can actually admit that you granted cert improvidently and just not decide the case. And there was some suggestion that the court should do that here because of the big implications of a wide holding. But again, we didn't get that. The majority here was content just to say, you've met realization in these facts. And so there is nothing to see here, no constitutional issue with the 965 transition tax. To me, I think the more interesting thing from Moore, again, I think it was built up that it could have been a very significant thing. It did not turn into one. Mm-hmm. But I think if you parse the tea leaves from where the various justices landed, I would bet that there is a majority that would suggest that a wealth tax for certain, and maybe a mark-to-market tax, might not be constitutional. And you get there from the concurring opinions from Barrett and Gorsuch, and the dissent from Alito and Thomas. I got that backwards.
Okay.
It was Barrett and Alito and Gorsuch and Thomas, both of which said that there is a realization requirement. Now, the majority didn't have to answer that question, but if I were betting, I would bet that if presented with the issue, you'd get at least one justice from that majority opinion who would say that a wealth tax, for example, did not satisfy the 16th Amendment. And I think that, to me, and you sort of see consensus amongst academics that is the likely implication of this case, is that if Congress were going to think about these sorts of taxes, they might need to go back to the drawing board, because I think there is a pretty clear inference from the case that that would not pass constitutional muster.
And why are we even talking, just for some context, particularly for those outside the U.S., why are we even talking about a wealth tax? The U.S. does not currently have a wealth tax, but it was a proposal by the Biden administration, and maybe just
Yeah, there have been a number of proposals. I mean, one of the Democratic priorities in the tax space in the last few years has been addressing wealth inequality. And, I think there's some observations that, particularly because we have a realization-based tax system, there are a lot of very wealthy people who own, billions of dollars of stock and never sell them. They might be able to borrow against that wealth and consume it, right, without taxation. And so there's a view that we should be going after that really is income to them in an economic sense, and we should tax it. And so you see a lot of legislative proposals. Senator Wyden has a mark-to-market proposal that is out there. Senator Elizabeth Warren has also talked about this quite a bit, and the Biden administration as well, that there is some desire, particularly in the progressive camps of Congress, to tax this unrealized appreciation.
And to your point, maybe we got some hints of how the Supreme Court may view this, but that'll have to be a future podcast.
Right.
All right. So let's move on to our next case, which is Corner Post versus the Board of Governors of the Federal Reserve. So what are the facts here?
Yeah, so this case, it dealt with the Federal Reserve regulation of the fees you can charge on debit card transactions, right? And that seems pretty dry and boring.
Nothing to do with tax.
Yeah.
We'll make it relevant, but keep going.
But, the issue there is in a number of areas of the law, there are statutes of limitation, right? Where you have a certain amount of time to sue to challenge a regulation. And the issue in this case is, when does that statute of limitation start? Does it start when the regulation was issued, or when your taxpayer plaintiff was injured by the regulation? And in this case, Corner Post was a business that the case ultimately went through the Eighth Circuit. And they had sued to say they didn't actually exist when the regulation was promulgated. Dodd-Frank was passed in 2010. I think the regulation was enacted or promulgated in 2017. And, here they are suing outside of the statute of limitations to challenge, had the statute started when the regulation was promulgated.
Just 6 years?
Yeah.
Yeah.
And their claim was, well, no, that should really start to run when we were injured by the regulation. And the court, just to cut through it, the arguments, agreed with them and said, your day in court should start when you are injured by the regulation. That's relevant here, particularly for tax, because there's a special statute that's relevant to tax called the Anti-Injunction Act, which basically says you cannot sue to prevent the collection of a tax until you're effectively injured by the tax, till the government tries to collect the money from you. And so there's inconsistent case law about the Anti-Injunction Act, but a number of courts have said that until the government has tried to collect money from you, you do not have standing, and you cannot, under this act, challenge that regulation. And in the tax space, the IRS has made some really smart arguments to say, well, these regulations were promulgated years ago, you were not injured by them, the 6-year statute has run, and therefore you cannot challenge the tax. And the practical effect of that is it would deny a lot of taxpayers their day in court to challenge a regulation when they were injured by it. I think the important thing to keep in mind for Corner Post is, now that the court is saying that the statute runs from the date of injury, then I think those arguments the IRS has been making in those other cases is likely to fail, right? And so this is going to widen the number of cases where taxpayers have the ability to challenge regulations.
And so do you foresee now, I mean, and I don't know if this is the Supreme Court addressed, like a potential flood now of additional claims, given that, really this is inconsistent with at least the IRS's historical position?
They didn't address that particular point, but I do think that's right, that you're already seeing a number of alerts from law firms in particular that there are a number of regulations that, we'll get into Loper Bright, maybe their validity is going to be subject to more question, and taxpayers are no longer going to have these procedural bars potentially challenging them once the government is trying to collect or enforce these regulations against taxpayers. So I do think we're going to see a lot of activity in this space, and it's going to be an interesting couple of decades as we watch this unfold.
Yeah, and maybe as kind of as a transition, we move to the last case within Loper. Maybe just remind listeners kind of how the legislative and regulatory process works, because you're talking about these regulations, but regulations generally only come after a statute. But maybe provide a little bit of context, and then we can go into the Loper Bright case, because I think that is relevant for this corner post discussion.
Sure. So constitutionally, under Article 1, Congress makes the laws, right? But they don't always do it perfectly. Oftentimes there are ambiguities in the legislation that they enact, or sometimes they just punt issues intentionally, like they'll give policymaking authority to an agency. They'll say the secretary shall propose regulations telling you what a proper allocation of certain deductions are. And in that instance, where there's either an ambiguity or there's an explicit delegation of authority to the IRS, Treasury and the IRS will fill in the gaps. This is what they've done historically by issuing regulations. And oftentimes those regulations are clarifying the meaning of a statute, but particularly where there are explicit delegations of authority, they are oftentimes expanding the application of the statute and making law that is not apparent from the face of the statute. So it's a two-part process. Congress is ultimately they have the ultimate say on what the law should be, but if they're not clear or they delegate some authority, that power then typically goes to an agency to fill in the gaps. And that's where I think this Loper case that we're going to talk about is very relevant.
Yeah, and that agency you're talking about is the Treasury Department, so that the Congress gives the Treasury Department the opportunity to issue regulations. And we can speak as international tax practitioners that, and understandably, this stuff is so complicated, particularly in international tax. I feel like, and maybe I'm biased because I spend most of my time within international tax, but it seems it's relatively common where Congress will delegate authority on particularly some of these super complicated issues to say, hey, Treasury, you're in a better position than we are as Congress to actually work out some of those details. So there is that express authority that's granted in those statutes. And then now we have to deal with these cases to figure out, well, has Treasury, has that agency potentially exceeded its authority? And what potential opportunities or claims do taxpayers have to push back on that?
Yeah, it's actually funny you mentioned that. A friend of mine who is a staffer on the Senate Finance Committee, who when I was in the government, worked with him, drafting statutes. Where there were complicated issues, he would often say, well, that's a Treasury problem.
Okay.
And that would show up as a reg grant for Treasury and the IRS.
And that makes sense to me. And frankly, I would argue that, Treasury, where they have deep technical expertise, you are one of those, and your colleagues, that they are arguably better positioned to be able to come up with those detailed rules because they have much more depth of expertise and knowledge to be able to do that.
Yeah.
So, all right, let's move to, because this is the other one. Moore got sucked a lot of oxygen out of the room, but this Loper Bright Enterprises versus Raimondo.
Yes.
So talk a little bit about what are the facts of that case, and maybe who's Loper Bright and who's Raimondo.
So yeah, this case, it was a fisheries case where the issue was there's this act, the Magnuson-Stevens Act, that the idea was monitoring and protecting offshore fisheries, right? And the way that happened in the statute, one of the ways is through monitoring of fishing vessels to make sure that their catch were within limits. And in several places in the statute, it specified that the vessels had to pay for these monitors. And in this case,
had to pay for the monitors to actually be on their ships.
Be on the ship, yeah. In this case, the statute was silent. With these particular fishing vessels, there was nothing in the statute that required payment for the monitors. And the National Fisheries Service had said in regulations, you do have to pay for these fishing monitors. And so that they argued in the lower courts, the statute was silent here, or ambiguous. And under the prior Chevron framework, which is no longer the law, we'll get to that, mm-hmm. If the statute was ambiguous, and a court so found, then the courts effectively had to defer to the agency's interpretation as long as it was reasonable, or the technical term is not arbitrary, capricious, or manifestly incompatible with the statute. And so the lower courts interpreting this Chevron framework, which comes from a 1984 case, Chevron.
A Supreme Court case.
Supreme Court case. Had basically sided with the agency and said the statute was ambiguous. This is a reasonable interpretation, so the government should win here. There have been, Chevron, when it was decided back in 1984, I don't think the justices quite realized what it was going to grow into. And it has really, over the years, turned into quite a bit of a handoff of policymaking powers from Congress to federal executive branch agencies like the IRS, or in this case, the Commerce Department. And I think it's fair to say, we'll get into some of the details, that the current Supreme Court is very skeptical of administrative power. And, you see that in a number of cases, and Loper Bright or Corner Post are both examples of that playing out, where this court is starting to rein in the agency's policymaking powers. Now, where's that power going? It's going back to the courts in this case, right? Because maybe just a little background for listeners on the Chevron.
Yeah, please.
Right? The Chevron Doctrine, as it evolved from the 1984 case, was a two-step process. Step one of that process was the court was supposed to look at the statute, use all of its tools of statutory interpretation, and try to see if there was a clear meaning of the statute. Does the statute directly speak to this question? If the answer to that was yes, that's the end of the case. That is the answer. There's no authority for the administrative agency to interpret it. But if the statute was ambiguous, right? So you can imagine, in tax, we oftentimes have statutes that say something must be proper, a proper allocation, or necessary and appropriate. Those sorts of words are inherently ambiguous, right? And so then you move on to step two, which is that interpretation the agency gave to that statute and its regulations reasonable or not arbitrary, capricious, or manifestly incompatible with the statute? And step two, historically, has not really been a very significant test. It's almost toothless, you might say. And so oftentimes if an agency can get to step two, they have won the case. It's really rare that you see an agency lose at step two. And so what the court in Loper said, they overruled Chevron, right? Now, we'll get into that. I don't think they actually overruled Chevron. The headline that Chevron is dead is overblown.
Okay.
But at least in a case like Loper or Relentless, which is the companion case, what the court said is, and this is really a separation of powers constitutional issue, is that, no, it's the courts that decide what the law is. And that goes back to Marbury versus Madison, right? That's the province of the judiciary.
Right.
And the majority opinion, although there were a lot of sort of constitutional atmospherics, it really was a statutory case. In the 1940s, Congress passed this provision called the Administrative Procedure Act, and it has a number of procedural rules around agencies making rules, but it also says that it is the court's job to decide what the law is. It sort of reiterates Marbury versus Madison in the text of the statute itself. And so the majority opinion said, well, we can't ignore those rules. We are the branch of government that's supposed to interpret the law. We have not been doing that job under Chevron. We've basically been saying, well, if it's ambiguous and there are multiple potential meanings, even if we think there's a best meaning, we'll let the agency win as long as their reading is reasonable. The rule now is, nope, if there's a best reading, that is the answer, full stop. And so I think the courts now, this is pretty clear, in a case of ambiguity in a statute, they're supposed to interpret the rules and come up with their own answer.
The court.
Right. Now, there's a really important caveat to that, right? And this is why I don't think Chevron is fully dead.
Good, because this was my follow-up question. Why is Chevron not dead?
And the court acknowledged that you can have Congress explicitly delegate authority to an agency. They do that all the time, particularly in tax.
Yeah.
And where that happens, there are some limitations on that delegation. I don't think we really have a lot of parameters around what those limitations look like. But as long as you're within those, then the agency can exercise interpretive or policy-making authority, right? And so I think Chevron is certainly dead for those class of cases where the statute is ambiguous and the agency is trying to put their gloss on what they think the statute means. That's dead. So now it's just the courts. They're supposed to read the statute and come up with what they think the best meaning is. But where you have these explicit delegations, there's still going to be some sort of deference. We don't know what that's going to look like. It may be arbitrary and capricious review. And I think, frankly, it's going to be a number of, like, maybe 2 decades of litigation figuring out what that means. And let's take this to the tax context.
Yeah,
I think
please.
that's really important. There are a number of explicit delegations throughout the code. The most important one is probably in 7805A, which says that the Secretary shall issue necessary and appropriate regulations to carry out the code. I don't think we quite yet know what that means. Like, if you read the majority opinion in Loper, it's clear that it's a statutory case. So if Congress does not like this result in Loper, they can overturn it. They may have already done that with 7805, right? What does that mean? Does that broad grant of reg authority mean that, Chevron still kind of applies in the case of tax regulations? We don't yet know. We'll find out. The other question that I think is really important is there are various different types of reg grants. Sometimes you'll have a regulation to provide necessary and appropriate regulations to carry out the purposes of a statute. Sometimes it will be to carry out the provisions of a statute. People place a very significant weight on the difference between provisions and purposes, suggesting that one might just be, carrying out, how does the statute get implemented, collected, reported, very ministerial sort of regulations. That would be the provisions grant. The purposes language, people think that might be a lot broader, and so that might be the sort of explicit delegation that Loper provided a carve out for. So we need to see what that is. I think that ultimately this is going to be fleshed out by lower courts. I don't quite know exactly what the standard is, and I think we're going to find out through years of litigation.
Yeah, and I think I share that view that this may not have the massive impact to tax regulations, given the authority that is granted just inherently in the Internal Revenue Code, and then also as we see of these particular statutes. And so, I think there have been a number of taxpayers, commentators that have thought, well, this could potentially turn the entire tax code and our regulation system on its head. And time will tell, right? But it appears that many of those issues are already kind of built into the existing statutory system. But there's a lot of tax regulations, and so any thoughts with respect to what should taxpayers take away from any of these cases? Does everybody lawyer up and start challenging regulations? And I've gotten a number of these questions, but kind of maybe here in conclusion, what advice do you have for taxpayers as a consequence of really all 3 of these decisions?
Yeah, it's funny. I think that we are seeing a number of taxpayers starting to think about regulatory validity more. And that's a process that I think started back in the Mayo Foundation decision, right? Which that was another Supreme Court case that basically said there was this notion of tax exceptionalism, that maybe the IRS got more leeway with respect to regulations than other agencies. Mayo said, nope, you're treated exactly like other agencies, subject to the same standards. Now, at that time, that was Chevron and the APA. Right. Well, now Chevron is maybe not fully dead, like the Monty Python line from Holy Grail, but it's limping for certain. And so I think there are a number of taxpayers who are looking at regulations where maybe that's not what Congress had in mind, right? And you could come up with a number of examples where you look at a regulation, you ask, is that what we really think Congress had in mind behind that statute? And the answer might be no. It's interesting. There's a law professor named Chris Walker who actually asked agency rulemakers, how often do you think about Chevron as your framework when you're promulgating a regulation? 90% of them said that they do take Chevron into account, which is contrary to sort of what I'll call the junior high version of what you think the regulatory process should be, which is, what did Congress mean here? That's what our regulation should say. I don't think agency administrators have actually practiced that way recently. Oh. So where you see that divergence between what we think Congress meant and what the regulations say, I think we're going to see a lot of challenges. For us as an accounting firm, this is hitting our doorsteps as auditors. We're having to evaluate taxpayers' claims. We're not front and center advising on the regulatory and validity, but we're having to assess the reasonableness for financial accounting purposes.
As we get additional guidance and as more cases come in, no pun intended, but as additional cases come in, we'll certainly talk about it here on the Cross-Border Tax Talk. So Wade, thank you very much for coming on. Excellent, as always, great summary of these cases, and just a very interesting area of the law. And I'm with you. This is going to take decades potentially to shake out. I mean, we're talking about cases from the 80s and before. So as those develop, we'll continue to talk about it here on the Cross-Border Tax Talks. But Wade, thank you very much for coming on.
Thanks for having me.
So thanks for tuning in to this week's episode of Cross-Border Tax Talks. Thank you, Wade Sutton, International Tax Leader for PwC's Washington National Tax Services Practice. I'm Doug McHoney, PwC's International Tax Services Global Leader. Stay tuned for another exciting edition of the Cross-Border Tax Talks podcast.
This podcast is brought to you by PwC, all rights reserved. PwC refers to the U.S. member firm or one of its subsidiaries or affiliates and may sometimes refer to the PwC network. Each member firm is a separate legal entity. Please see www.pwc.com/structure for further details. This podcast is for general information purposes only and should not be used as a substitute for consultation with professional advisors.